Hello, so today we will be discussing about the topic case study of Meor Atiqulrahman and Fatimah binti Sihi. So this is presented by Adla Omar, Raiki Alfredo, Norcia as well as Amira Safia. Without further ado, let's dive into each topic in depth. So the first thing is facts of the case. In this case, the defendant, which she was a principal in Sekolah Kebangsaan Siti Hilir, had issued a rule called the 1997 School Regulations, where it prohibits all pupils and students from wearing robe, turban, hat, ketayab, and purdah as a uniform at school and advises the claimants to stop wearing the turban as a part of their school uniform. The three appellants who wore turbans while at school refused to take them off their turbans on the grounds that it was the Sunnah of the Prophet. Consequently, on 3rd November 1997, the appellant were expelled from the school by the defendant, which leads the claimants to challenge their dismissal in court. Furthermore, in this case, in the High Court judgment, Datuk Muhammad Nur Abdullah void Fatimah's decision, who expelled the three students on the ground that they were wearing turban to school. Therefore, Fatimah had no authority to take any action against the plaintiff because it is based on the Article 3, Clause 1 of the Federal Constitution. However, the court held that the School Regulations 1997 was unconstitutional and there is no prohibition to wear the turban. Therefore, the decision of the High Court has been reversed in the Court of Appeal, and the judge stated that he did not see the School Regulations 1997 that prohibits the appellants from wearing the turban contravenes the freedom of religion enshrined in Article 11, Clause 1 of the Fundamental Liberties under the Federal Constitution.
Furthermore, in this case, the court granted leave to appeal on one issue only, which is whether the regulation prohibiting the wearing of turban by school people violate Article 11, Clause 1 of the Federal Constitution. The matter before this court is not whether the wear of a turban is constitutional or not, but whether wearing a turban as part of their uniform during school hours is considered unconstitutional under the ground of school regulation in 1997. Prior to us, the appellant Land Council claimed that the regulation prohibiting the wearing of turban by students violated Article 11, Clause 1 of Federal Constitution.
In the case of Meor Atiqulrahman bin Ishaq and others, and Fatimah binti Sihi and others, the High Court ruled that the prohibition on the wearing of turban was contrary to Article 11 of the Federal Constitution. But the High Court decision was reviewed in the Court of Appeal, and the Court of Appeal stated the 1997 school regulation prohibiting claimants from wearing turbans do not violate the freedom of religion enshrined in Article 11, Clause 1 of Fundamental Freedoms under the Federal Constitution. Therefore, the ratio decidendi of the Court of Appeal on the 1997 school regulation is valid because, firstly, the wearing of turban is not an obligation or an integral part of Islam. Secondly, it is prohibited for not being uniform with other students in wearing their uniforms. Thirdly, the court found that the learned judge did not receive scattered evidence proving that the wearing of turban is compulsory and integral to Islam.
So furthermore, applying the rules of law in the chosen case, there are enough evidence of the case that wearing the turban is not completely provided and does not contravene Article 11, Clause 1 of Federal Constitution because the first one is the appeals were advised by defendant to substitute the turban with songkok in school only, but the claimants are free to wear the turban outside of school. And the second one is the appeals are not allowed to wear the turban during school hours as part of the school uniform. And the third one is nothing prevent the appeals from switching to another Islamic school, for example, a pondok school which will permit them to wear the turban. Moreover, the Court of Appeal had to rely on the case of Hajar Halimatul Saida versus Public Service Commission Malaysia 1994, holding the judgment that the three claimed constitutional right was not treated, although they are provided from exercising their religious practice.
So last but not least is the court holding. So in a nutshell, in the judgment of the Court of Appeal, the court reversed the judgment of the High Court. This is because the judge of the Court of Appeal does not see the School Regulations 1997 that prohibit the claimants from wearing the turban contravenes the freedom of religion enshrined in Article 11 of the Federal Constitution. Therefore, the principal of the school, which is the defendant, won in the Court of Appeal judgment because, according to the judge, she stated that the wearing of a turban is not an obligatory or an integral part in the Islam religion. Therefore, that is all from us. Thank you.